Hello and welcome everyone to Mayor Brown's webinar, U.S. Enforcement and Cybersecurity Outlook for the Oil and Gas Companies. My name is Mike Lennon, and I am a partner in the Litigation and Dispute Resolution Group and a member of the Global Leadership Team for the Oil and Gas Practice. I'm joined today by my colleagues Stephen Lilly, Jason Linder, and Tamara Solomon as panelists. Before we turn to speaker introductions, we'd like to mention a few housekeeping announcements. Please note that when accessing Mayor Brown webinars via our Zoom platform, we suggest avoiding software such as Citrix to decrease disruption or quality loss. Also, please note today's webinar is being recorded. If you have any questions as we go along through the presentation, we invite you to submit them in the Q&A function at the bottom of your screen. I will be monitoring that, and I will be happy to call out questions to our presenters as they arise. We'll do our best to answer the questions live, and of course, if you don't get your question answered, please feel free to reach out to any one of us afterwards. Regarding CLE credit, we will provide an alphanumeric code for U.S. participants during this presentation. In order to receive the CLE credit, U.S. participants must record the code on the virtual sign-in sheet that was emailed to you with the login instructions. With that said, let's get started. I invite my colleagues, Stephen, Jason, and Tamara to introduce themselves, and then we will kick it off. Stephen.
Thanks very much, Mike. As Mike mentioned, my name is Stephen Lilly. I'm a partner in the DC office and in our cybersecurity and data privacy practice, as well as our litigation practices. I really appreciate the chance to be with you today and talk about cybersecurity, the outlook from a U.S. perspective for policy and law. I spend a lot of my time working on cybersecurity issues relating to critical infrastructure, including the oil and gas industry. So this is a topic near and dear to my heart. So thanks very much for the chance to speak with you today.
I'll go next. Hi, everybody. I'm Jason Linder. I am a co-chair of Mayor Brown's Global Anti-Corruption and Foreign Corrupt Practices Act practice. I spent, prior to returning to private practice, I spent 10 years as a prosecutor at the U.S. Department of Justice. The latter half of that time as a senior prosecutor at Main Justice, investigating and prosecuting exclusively Foreign Corrupt Practices Act cases and related money laundering, fraud, and other cases. And I, like Stephen, I'm delighted to be with you today and have an opportunity to share with you the firm's views about what enforcement has looked like at the beginning of the Biden administration and will likely continue to look like over the next couple of years.
And my name is Tamara Solomon. I'm also a partner in the Washington office, and I head up our export control and sanctions practice globally. I've been practicing this area for about 20 years, spend most of my time working on both the compliance and investigations side of this practice area, and spend a lot of time working with energy sector clients, both US and non-US, in managing sanctions and export control issues. And very happy to be with you today.
Great. Well, our agenda today you have there on the screen, and we're going to kick it off with cybersecurity. And Stephen, it's your show.
Great. Thanks very much, Mike. So as I mentioned sort of in the introduction, that there is a lot going on with cybersecurity law and policy in the United States, and particularly with respect to the oil and gas industry and critical infrastructure more broadly. I imagine since you're here, this cybersecurity is probably already a focus area for you and your companies. And I imagine that you will have varying interests in different sort of areas of policy and law with respect to cybersecurity. But to try to distill it today, I'm going to cover 4 primary points to give an overall outlook on cybersecurity for the oil and gas industry from a U.S. perspective. So first of all, the first point is that cyber threats to the oil and gas sector are significant, and they're here today. Second point, the corresponding legal risks from these attacks are significant. So sort of think about that as the baseline against which the Biden administration is operating. There are significant cyber threats, significant corresponding legal risks. The third point is against that baseline, the Biden administration is very focused on cybersecurity. and particularly the cybersecurity of the oil and gas sector and other critical infrastructure. So we should expect the Biden administration to use all available tools to raise cybersecurity standards in the industry going forward. And fourth, while the specific legal requirements will vary by company, depending in part on where you sit in the industry, there are some practical steps that any company can take to reduce legal risk. So I think that's sort of the good news, the silver lining here. There are significant threats, significant legal risks, expectations are going to raise, but the good news is that some of the building blocks for mitigating those risks are going to be very familiar to people, even if they don't have a lot of experience with cybersecurity, because they're generally speaking a lot of the same building blocks that you would use to manage other significant risks that your company faces. So with that sort of overall background, let me jump into some specifics around the cyber threats to the oil and gas sector. So, as I mentioned, the attacks are here. I think there was a perception a few years ago that certain critical infrastructure systems were not necessarily a key risk because they weren't necessarily the type of systems that attackers would focus on, or they were too old to attack, or they were too separate. They would, removed from, enterprise networks and couldn't be attacked. And I think at this point, what we've seen has made clear that everything is effectively connected one way or another. And unfortunately, there are both targeted and incidental attacks that can put all systems at risk. So by target, I mean, a sophisticated nation state who wants to do harm to American critical infrastructure, whether it's the oil and gas sector or otherwise, focusing on potential sabotage. Incidental would be something like the Colonial Pipeline attack, where the purpose of that attack wasn't necessarily to shut down oil, delivery of products across the United States. They were just trying to make money, but the effect of it was to affect the infrastructure. And in addition to that, in addition to the attacks being here, the consequences are here as well. So there are very significant practical and legal consequences for companies, as you've already seen. Just to walk through Colonial Pipeline a little bit. As I mentioned, this was not a targeted attack in the sense they weren't trying to shut down oil and gas infrastructure, but that's what the effect was. And if you saw, the consequences for the company were really quite significant. I think it was probably quite jarring for folks to see, people speaking from the dais in the press room at the White House, talking about the specific decisions that were being made by the company, paying ransom, not paying ransom. These things were sort of being debated in real time by sort of the national press and by political leaders. There was subsequent litigation. There was subsequent Hill testimony that was required. So this really just goes to show that today the risks are very, very significant. And it may be the case that not every oil and gas company is going to have that incident, of course, and not going to face those types of practical consequences in the near term. But I think as Colonial Pipeline demonstrated, if you are unfortunate enough to be that company, to be the one that has a substantial attack, the consequences can be very, very significant. So just to sort of walk through just a bit more tangibly, what the potential consequences can be. So as you see on the left-hand side here, we've got potential safety impacts, you've got business disruption, you've got environmental harm if infrastructure is releases some sort of chemical into the environment or what have you. If you're going through a refining process and that gets compromised, you have potential loss of product integrity, and then you have obvious sort of financial loss and reputational harm that flows from those types of consequences. I think as we saw already, these are all very, as I mentioned, very present. These are very, very real risks. I think, they aren't, as I mentioned, they're not risks that are necessarily going to be realized for every company in the sort of the near term, but they are very significant risks with a sort of a low probability that you need to think about how to manage. And you'll probably notice I haven't mentioned the word data breach yet. Obviously, any company that holds employee information is at risk of a data breach of that information. I imagine you have other sensitive information that you hold. There could be a loss of confidentiality around that. I don't want to totally discount those risks, but for folks in your industry, I would expect that mostly you're going to be thinking about the sort of the attacks on infrastructure itself and all the sort of significant consequences that can flow from that. So that's sort of the background on the threats. I'm sure things are very much top of mind for you. Talking a little bit about the legal risks, again, there are a very diverse set of cyber attacks that could be, visited on folks in the oil and gas industry. As a result, the consequences could be very, very broad, very varying across those, diverse incidents. But just to give a sense, I mean, unfortunately, essentially any type of litigation is conceivable after the, certain types of incidents, depending on, again, where you sit in the industry and, your the specifics of the incident. But, you can certainly imagine mass tort litigation, consumer class actions, commercial litigation with business partners, and then, litigation sort of relating to, the oversight of the program. So that would be a derivative action or representations made about the security of the company. And that would be through securities class actions. And these are all different types of litigation that have already been prevalent for other cybersecurity incidents, outside of the oil and gas industry. And we've already seen, to some extent, after incidents affecting the oil and gas industry. And then with respect to regulation, as I mentioned sort of at the top, I do think you're going to see rising expectations. You are going to see increased regulatory enforcement actions. Again, the specifics of your company are going to dictate which regulatory frameworks you're subject to. But these are all, really should be top of mind. And as you think about those risks, I think some, key piece to think about is what are some key legal risk multipliers? So if you have unclear allocation of roles and responsibilities, if an incident hits and everybody's looking at everybody else, expecting someone else to, address it, that's obviously going to be a, risk multiplier. A lack of policies and procedures, relatedly is going to be, a risk multiplier. Lacking of internal training or education, failure to address common security areas, or having unfavorable contractual provisions, with key counterparties. These are all things that could make your situation much worse from a legal perspective, if an incident hits. And before I sort of move on to the next point, I do want to emphasize that, I've mostly spoken here about litigation and regulatory risks after an incident, but I do want to emphasize that it's possible for these legal risks to be realized even before an incident. So you can imagine, because there's a vulnerability report, or someone does a report and says, X company has, runs these systems, and we can see them on the internet, they're not secure. You could have a lot of these same issues even without actually being attacked. And obviously, you could have a government inquiry without actually being attacked, so they could be assessing you, what have you. So that's sort of the baseline, as I mentioned. So turning to what the Biden administration is doing, I think really big picture, as I mentioned, I think the Biden administration is very focused on cybersecurity generally. They're obviously focused on the cybersecurity of Americans' personal information, but I see a greater emphasis on the cybersecurity of critical infrastructure, including the oil and gas sector. And what I see is the Biden administration trying to fill gaps. There's sort of a patchwork of different regulatory standards. Some are binding, some are non-binding across different parts of critical infrastructure. There's a perception that certain sectors of critical infrastructure are further ahead than others. The financial services, critical infrastructure is generally perceived to be sort of the most advanced. There's a perception that a lot of operational technology, so think about, the actual equipment that moves oil and gas around, is less secure. And I think that's sort of a widely held view. So I think there's a general sense that there are gaps to fill, and the Biden administration is going to try to fill those gaps as well as possible. And it's going to use every tool in its toolkit to try to achieve that. So to demonstrate what I mean by that, let me highlight three particular actions the Biden administration took. So first, the cyber executive order. This was not directly applicable to most of the sector. This was focused on government contractors and the government itself. But one of the things it made clear was that it viewed the security of IT, so your traditional enterprise systems, and the security of OT, so operational technology. So again, the big critical infrastructure, the big, the actual infrastructure itself, as equivalent, as equally important. And I think that really sent a message that expectations for operational technology, or sort of the infrastructure itself, are really going to be raised, including around secure development, incident notification, having secure architectures, essentially that operational technology is not going to be overlooked. It will be getting equal amounts of focus going forward from the government. And that was a point that was really emphasized in the National Security Memorandum that was focused on the security of critical infrastructure systems, and again, particularly focused on sort of that operational technology. And that's something, that's notable for a couple of reasons. One is it had an information sharing provision, but the second is it made clear that they are going to push best practices for security for these operational systems. And this is an example of what I mean by sort of gap filling. I think the Biden administration saw a gap where the existing frameworks, in their view, weren't sufficient to cover off on all the major priorities they had. And they wanted to fill this with best practices and a new framework. And that's what they're doing. And I think actually the first piece of this is going to be supposed to be published today by DHS. So we'll see what it looks like. I think practically speaking, what it means is there will be a statement of government expectations of what sufficient security looks like for systems that are not otherwise subject to a regulatory framework. Essentially what it means from a legal perspective, if someone sues you, they will have a yardstick against which to measure pretty much any, the security of any system that's operated in an infrastructure capacity. And then the final point to mention, I'm sure this will be something very familiar to a lot of you, the two TSA pipeline directives established new and stringent and mandatory cybersecurity requirements that go well beyond those imposed on many other critical infrastructure sectors. These pipeline directives moved away from the voluntary approach that had long been in place and put in place, these very specific standards, and standards that really are quite surprising to, I think, to a lot of people who follow cybersecurity, because they go well beyond what is required of many other companies. So, for example, to have a cybersecurity coordinator who is available 24 hours a day, 7 days a week to the government, having a 12-hour reporting timeline. I mean, these are things that, really, in my view, sort of send a shot across the bow. And, I think everyone should be looking at, even if you're not subject to these directives, to think through, if we were made subject to something like this, if we were sued and similar standards were tried to be applied against us by in the litigation, how would we stack up? Because I do think these are, important yardsticks that are going to be used or tried to be used by other regulators and litigants going forward. And just very briefly to finish, I mentioned, the trajectory that the Biden administration is sort of putting us on for oil and gas cybersecurity. And they're obviously going to be very specific analyses that you will need to do for your own particular company and your own particular systems, your own particular risks. So I don't want to paint with too broad a brush, but in terms of just some key building blocks of mitigating these risks, understanding your risk, having effective governance, having appropriate policies and procedures, maintaining and practicing use of an incident response plan, and responding effectively when incidents occur. Those are some of the key building blocks that are the focus of pretty much every regulatory framework or best practice framework for cybersecurity, and I think will continue to be core issues. So while these are really complex challenges, and these challenges will be very, company specific and fact specific, and the legal risks will be fact specific, I do think that, using these building blocks, which hopefully will look familiar from other types of, risk management processes, can be very, very helpful for companies who are sort of starting out or continue on their journey to mature their cybersecurity programs to address these risks, particularly as these risks, the legal risks for companies grow with increased sort of legal scrutiny on their practices going forward. So yeah, hopefully that's a helpful overview of the cybersecurity outlook for the next couple of years.
Thank you, Stephen. I have a quick question for you. You mentioned regulatory enforcement if it's determined that a company has inadequate policies. Can you give us a sense of what the continuum of enforcement actions or penalties might look like, given the current administration's emphasis on cybersecurity?
Yeah, I think the administration is probably going to be somewhat reluctant to have a lot of different enforcement actions. They're probably not. My gut is that they're not necessarily going to pursue particularly extensive penalties necessarily right off the bat. But I think that the reputational consequence, to the extent that there is any action, would be quite significant. And one of the problems we see in cybersecurity is oftentimes when there is, a regulatory action of some kind, there's follow-on litigation. It can, put pressure on the company to make broad changes to its internal governance. So I guess really big picture, my impression is that, or my prediction would be that not just the exposure from a fine perspective may not be particularly enormous right now. And obviously this is going to vary by company and based on the facts, but that the consequence for a company and the internal disruption that might follow from some sort of regulatory action could be much more significant, practically speaking.
Okay. Again, everyone, good morning or good afternoon. I'm Jason Linder, one of the co-heads of our anti-corruption practice. I will apologize in advance that I don't have Stephen's charming accent, but we'll struggle through as best as we can. So I'm going to talk briefly today about what anti-corruption, particularly foreign anti-corruption enforcement, has begun to look like and will likely continue to look like in the Biden administration. I think to set the table, the first thing that was kind of a surprise to those of us who practice this area is that foreign corruption enforcement was a high point of white collar enforcement more generally in the Trump administration. Overall, white collar criminal enforcement and by the Department of Justice and its U.S. attorney's offices, and regulatory enforcement by the Securities and Exchange Commission, the CFTC, and other agencies was down across the board during the 4 years of the Trump administration, except for FCPA, Foreign Corrupt Practices Act cases. When I left the department in 2017, there were about 25 full-time prosecutors investigating and prosecuting nothing but FCPA cases. That number stands between 35 and 40 today. They have expanded their role of prosecutors, the ranks of prosecutors. There were 3 full-time FBI squads before the Trump administration focusing on foreign corruption cases. There are now 4 throughout the country, and there are about 40 full-time SEC attorneys and accountants and other professionals who focus on nothing but FCPA cases. Those resources have led to, by the end of the Trump administration, led to huge resolutions. So in 2020 alone, the year began with Airbus paying about $4 billion to resolve Foreign Corrupt Practices Act and related cases, and ended in October with Goldman Sachs paying about $3 billion in total worldwide for its involvement in a huge Malaysian embezzlement and money laundering scheme. There's every reason to think that that trajectory of vigorous enforcement and intensive resource focus will continue in the Biden administration. All of the Department of Justice and SEC officials who have spoken publicly have said that their pipeline of cases have never been more robust. And I can say that, on this side, representing companies under investigation by the department and by the SEC, that there's no abatement, even during the pandemic, of investigative activity and scrutiny. In addition, Congress has recently given the Department of Justice 2 additional investigative tools that will allow them to make more cases and to make more robust cases. One of those tools is a whistleblower program related to money laundering cases that is similar to, may well become similar to, it's very nascent stages, similar to the very successful whistleblower program that the SEC has had since Dodd-Frank a decade ago. The SEC has paid out hundreds of millions of dollars of whistleblower rewards for bringing in FCPA and other securities related cases. And the department now is beginning to stand up its own program, which will increase its pipeline of potential investigations and cases. The second tool that Congress gave the department earlier this year, late last year, that may substantially increase its ability to make its cases is the ability to subpoena foreign bank accounts directly of any bank anywhere in the world for any account for any reason, so long as that bank maintains a US correspondent account. Previously, the department, to get those bank records, would have to go through a formal process called the mutual legal assistance treaty process. They'd have to go through a formal process that could take years. And if a complex corruption scheme, as it often did, had transactions going through multiple countries, every request to country A and then country B and then country C could add years to the investigation, which as a practical matter meant that a lot of cases didn't get made and a lot of money trails didn't get followed. This new law allows the department to send out its own subpoenas and not rely on its foreign counterparts to any bank anywhere in the world and get bank records much more quickly. That should speed up cases and make them broader and more robust from the department's perspective. I will also just say briefly that the Biden administration has made a number of appointments and hired a number of people who are very seasoned and experienced in the space, which should, I guess, further streamline their ability to make these cases. I think that you should expect that based on what we're seeing and the clients we have, that there will be a lot of end of year activity in Q4 of 2021 as the department starts to bring those cases. Energy companies, it's no surprise to everyone on this webinar, remain a central focus of the department's foreign corruption and the SEC's foreign corruption enforcement regime. That's true here in the US. There are cases that have been made just in the last couple of months involving bribes to PDVSA in Venezuela. Still a number of cases coming out of the Petrobras car wash investigation of the last 4 or 5 years, including Amic Foster Wheeler resolving in June with the Department of Justice. And there's still some Unaoil related cases that are coming through as well. It's also true with the Department of Justice's and the SEC's foreign counterparts. Just 2 or 3 weeks ago, Brazil charged 2 executives from an engineering company called Doris for Petrobras related bribes. And just yesterday, Monaco has taken steps to further investigate Unaoil related activity involving SBM. So the department, in addition to its robust resources and its new tools, takes an incredibly aggressive interpretation of its of the beat that it walks, of the scope and jurisdiction of the FCPA. It already, as many of you may well know, the FCPA already covers any company anywhere in the world that issues US stock. It covers any US citizen and any US company anywhere in the world. And it covers purely foreign companies and individuals, not US citizens, not issuers of US stock. If anyone involved in a scheme takes one action in furtherance of that scheme while in the United States. You have a 10-year corruption scheme. There's one meeting in Houston next door to Mike Lennon, and the US has jurisdiction for the full 10-year scheme. That's not enough for the department. They have, in recent litigation, taken the position that the FCPA covers not only issuers of US stock and US companies and persons and foreign people who come to the US for any reason to further their scheme, but also anyone who aids and abets them or anyone who conspires with them anywhere in the world. Somebody over whom the US would ordinarily have no jurisdiction. So far, the department is batting 500. In one of the cases they're litigating, they've won, and one they've lost, but it's an area to watch because it the department effectively is seeking worldwide policing power. As with what Stephen said about cyber enforcement, the Biden administration has been active in issuing memoranda and executive orders that are related to this. Mike, did you have a question? Or
I do. In relation to that aggressive enforcement, what if a host country precludes the correspondent bank from complying with disclosing the information of other account holders pursuant to justice or a treasury subpoena? So you've got a foreign bank that's got a local branch, and their resident jurisdiction precludes them from complying.
Right. So John, it's a great question. And I will say that this is a brand new area. Just yesterday, one of my actually really close friends, who's now number 2 in charge of the FCPA unit in the Department of Justice, talked about exactly this issue and talked about this new power that the department has to subpoena these records. It seems that they haven't yet used it. I will tell you, I haven't yet seen a client who has received one. And we have a number of, in addition to energy clients, we have a number of financial services clients, and we haven't yet seen them come across the transom. But the number 2 in charge of the FCPA unit, her name is Linder, said that they will use that tool sparingly because of diplomatic concerns like the ones that you're addressing. I think the short answer is this is not yet an area where there are blocking statutes, or the sort of things that Tamara sees where there are rules about not complying with US sanctions enforcement regimes. That hasn't happened yet because this is brand new. My sense, and who knows, but my sense is that if a host country tried to say, so let's say Germany said, Deutsche Bank, you have a correspondent account in the US, you can't comply with the US subpoena unless they go through the formal MLAT process, mutual legal assistance treaty process to Germany. I think that the penalty, the pain that sort of stands behind the Department of Justice or the Treasury subpoena is kicking Deutsche Bank out of the US financial system. I don't think that would happen with Deutsche Bank, but if there's a small bank that only has this tiny correspondent account, which doesn't even have to have a physical presence here, it just allows them to make dollar-denominated transactions. I think that what stands behind it is the US kicking them out of the US financial system. And so if a host country said, you can't comply, the US would say, that's fine, you can't do business here. That's my guess about how to play out, but it's a really great question, and it is an area to watch as enforcement activity using this tool continues. My pleasure, John. Thanks. That's a great question. And questions are really fun for us. So if you have questions, please ask them. We'd love to address them. So as I was mentioning there I think it was in June, the Biden administration issued an executive order about foreign corruption that harnesses together not just the Department of Justice and the SEC and a couple of other agencies that have more recently gotten into the foreign corruption enforcement game, like the CFTC, but it's an all of executive branch, all of government initiative that includes the State Department, the Office of Director of National Intelligence, the CIA, Energy, Commerce, DHS, and missing a bunch of the National Security Agency and a bunch of others, to come together to coordinate and to pool their resources to more robustly investigate and prosecute foreign corruption cases. So even though there's been a continual upswing for the last 6 years, every year is a record year in the FCPA. Every year has more enforcement actions and more dollars in resolutions than the year before it. So even though there's a huge upswing, the Biden administration has said that it wants to marshal the resources of a number of other departments to assist the Department of Justice and the SEC in its investigations of these cases. As I mentioned, the Biden administration has put at the helm of various components of government that deal with these cases really seasoned, experienced former prosecutors who know their way around these cases, know their way around investigating in the furthest corners of the globe, and will continue to make these cases. Some of my friends at the department and the SEC have left recently to join us here on the side of the angels in private practice, but they've been replaced by people who've been in the trenches for a very long time and will continue moving forward with enforcement. Let me just make a couple more points on this slide and I'll advance. So one of the ways in which the department, in particular, also the SEC, has expanded its resources and expanded its ability to make cases is by building close, cooperative, productive working relationships with its foreign counterparts. So it used to be 10 or 15 years ago that the department mainly got evidence through these really slow bureaucratic processes of sending out treaty requests and waiting a couple years and knocking politely on the door and asking if they might have any evidence. And now they work really closely with Brazil and with the UK and with Singapore and Malaysia and Australia and around the world. And that allows them to have eyes and ears everywhere and to gather evidence and witness testimony very quickly and much more effectively, which allows them to make much bigger cases. And you see that has borne fruit just in the last year. I mentioned both the Goldman Sachs and the Airbus resolutions of last year. Those weren't just US resolutions. Those were coordinated resolutions. In the Goldman case, it was money went to Singapore, Malaysia, Hong Kong, the UK, and not just the Department of Justice and the SEC, but a number of other US state and federal agencies. And in the case of Airbus, it went to the US, the French, and UK authorities. And so you see the fruits of this close coordination and their ability to bring massive cases in a coordinated fashion. As Stephen was saying about ways that you can mitigate risk and having in place a good sort of cybersecurity risk assessment and program, it's true in the anti-corruption space as well. The Department of Justice has put out guidance in 2017 about what it expects companies' compliance programs to look like. And it has updated that guidance just last summer. The Department of Justice officials who run the FCPA program speak constantly, and they speak constantly about this. in the FCPA space and more generally in sort of white collar and other related risk areas, there is an increasing focus from the government on data analysis, but really getting plugged in if you're a compliance program or a legal department, getting plugged into the data that other parts of your company have, what finance sees, what audit sees, what other components are seeing, and using that data not just to analyze, but to figure out how to do predictive real-time monitoring so that you can address risks more effectively and proactively. The last thing I'll say on this is that at the end of a corporate resolution with a substantial corporate resolution, it was the norm in the Obama administration to impose an independent corporate compliance monitor as part of the resolution. For 2 years or 3 years or however many years, a lawyer that looks a lot like Tamara or Stephen or me would sit and rifle through a company's operations and its legal department and wherever to see whether or not the compliance program was working in practice and be the eyes and ears of the SEC and the department. Those were almost non-existent during the 4 years of the Trump administration. There were, by my count, 3 monitors. There were 6 monitors in the last year of the Obama administration alone imposed. I believe over the 4 years of the Trump administration, there were 3 total over 4 years. That's going to change. There's every reason to think that the current leadership of the department and the SEC will be aggressive in finding reasons to impose monitors. And so that's one thing that will be coming down the pike. I'm going to touch very, very briefly on domestic corruption and just say that, as I mentioned at the outset of the last slide, FCPA enforcement was a sole high point bright spot of white collar enforcement. Domestic anti-corruption, public corruption was not. Those cases were really down both at Main Justice and across the U.S. Attorney's offices. That will change. There will be a renewed focus in the Biden administration on in rooting out and penalizing, punishing domestic corruption. And there is a new government agency that's being discussed to oversee and enforce federal anti-corruption and ethics laws. And there's been a pledge to strengthen, not just as we were talking about the SEC's and the department's whistleblower laws with respect to white collar money laundering securities cases, but also ethics and domestic corruption related whistleblower laws.
All right, Tamara, what do we know about sanctions enforcement, or what do we predict about that?
Thank you, Mike. And again, very happy to speak with all of you. I'm going to rely on Jason to move the slides for me here. Again, so I focus on sanctions and export controls. This is a space where there's a very close relationship with foreign policy and national security, and those impact how the law is interpreted. In many ways, the interpretations are different based on the country, even with what would appear to be very similar legal frameworks. With respect to the Biden administration, I think there was a lot of anticipation with the administration coming in as to how much the Biden administration would depart from the prior administration in terms of policy, in terms of law. And there are areas where of law where we have seen significant departure. This is not one of them. The overarching theme with this administration, and this is clear through both the early policy pronouncements as well as some of the actions that we've seen to date, are a commitment to countering foreign adversaries, including Russia and China, notably for this discussion, a very broad view of national security and foreign policy interests. And here the energy sector is often a focus because of its ability to generate revenue for countries like the ones that I've mentioned, as well as the more sort of traditional rogue state actors that we're used to seeing in the sanctions space. Greater internal coordination. I think the Biden administration has come in with a view that many of the sanctions, the use of sanctions tools, the use of export control tools in the past administration, while aggressive and while the new administration doesn't necessarily depart in terms of policy objectives, also there are a lot of places where those tools were used in ways that were not necessarily internally coordinated. So we saw differences, for example, between the State Department approach on some sanctions issues and the Treasury Department approach. And that really came through in both in terms of how the laws were announced, in some places maybe a little bit immaturely, and also in terms of the positions that were articulated by these agencies. So there's I think an emphasis on coordination internally among the departments, and then also a greater emphasis on foreign cooperation. So all of those kind of result in an approach to sanctions in this space that is going to be probably less noisy, but essentially much more of the same fairly aggressive use of these tools and a theme of continuity. A practical example that some of you may be familiar with in this space is that the use of both export control and sanctions tools on CNOOC, an important player in the energy sector globally, Chinese entity. And I mentioned CNOOC because I think it illustrates some important challenges in this space that may inform our consideration of what we might look for when we're thinking about kind of the Biden administration and the coming years. One is that it reflects the use of sanctions against important major state-owned entities and major players in the market. So we're not just looking at traditional rogue state actors. We tend to think of Iran, we tend to think of North Korea when we're thinking of the sanctions space. But what we've seen over the last several years, certainly with the Trump administration and even the Obama administration, and we expect this to continue, is a more aggressive, expansive use of these tools against entities that don't really fit that mold. And that has important implications because these are parties that have significant impacts on supply and distribution chains. These are parties with major global business partnerships and global footprints. And that's another sort of issue, is that we're not just talking about the targeted territory like we are when we're talking about North Korea or Iran, for example. We see issues come up, whether we're talking about Russia, whether we're talking about CNOOC or other Chinese energy majors. These issues are coming up in Latin America. They're coming up in East Asia. They're coming up in Europe, and that's a reflection of the global impact these new sanctions targets have. Another issue with the CNOOC is the complexity of the targeted sanctions. So the restrictions on a company like CNOOC or Sinopec or some of these other the Russian energy majors are not comprehensive, but they are targeted, and this means more complexity, more nuance in the way that the sanctions are employed and what companies can and can't do, and that introduces some compliance challenges as well. And then I think the final issue that I think the designation of a company like CNOOC illustrates, as we think about some of the themes that I'll talk about, is the risk of conflict of laws issues. And we're seeing that more and more emerge as we're targeting countries like China or like Russia that maybe have more global clout and influence and maybe more market influence. We see a little bit more willingness to use domestic laws to counter the impacts of US sanctions and export control issues. This is probably most prominently reflected by China, which has implemented a number of legal tools over the last couple of years, and which we've seen expand those tools actually since the incoming Biden administration, perhaps as a test of the administration's willingness to proceed on this track. And that's going to introduce complexities, I think, that we're already seeing when we look at contract documentation, when we look at financing of projects, when we look at just operational business planning issues. These conflict of law issues are becoming more prominent and a challenge for companies to deal with. Before talking about sort of some of the policy signals from the Biden administration, I would just mention one contextual point, which is that the Biden administration doesn't operate in a vacuum. Congress is a key player precisely because of the nature of these sanctions. They relate to national security and foreign policy interests. So the Biden administration, like the Trump administration and other administrations before it, have to deal with a complex and sometimes unpredictable dynamic with Congress. And that comes up in each of the sanctions regimes that I'll talk about, some more than others, but certainly Russia, Iran, China are all lightning rods for congressional political pressure on the administration. There are a number of legal tools that Congress has used and is increasingly using to, if not force the president's hand, then at least require the administration to address how it's using sanctions in these spaces and apply political pressure and maybe impose a political cost. That has some impact on what the administration calculates in terms of how it's approaching sanctions. And there again, we see that in cases like Nord Stream. We see that in congressional pressure around China and some of these other jurisdictions. So maybe with that,
we have a question.
Oh, sure.
That relates to CNOOC, so I think I'll interject here.
Sure.
What to do if you are a supplier for a government and your contracting party is assigning the contract to a JV, which has 5% partnership of CNOOC. The supplier contract does not entitle you to oppose the assignment. What are some of the things you could do to try to protect yourself if that were to implicate a sanction?
Yeah, so thanks for the question, and obviously I'll look at this question as sort of a platform to illustrate some of the complexities in this area. Obviously, we should talk about specific facts if we're giving advice. But I will say, one of the things that you need to consider when it comes to CNOOC, and this is illustrative of some of the other sanctions that I'll reference when I say targeted sanctions, CNOOC is not off limits. CNOOC is subject to both OFAC sanctions restrictions and export control restrictions, and none of those. When I read this fact pattern, I don't see a fact pattern in which either of those complex regimes precludes the arrangement. I do see a fact pattern in which CNOOC status, which could change over time, could pose complex risks for you in this circumstance. I do see a circumstance where the export control restrictions on CNOOC, for example, might impose, and those are, just to be clear, restrictions that relate to fairly common commercial tools that are used for exploration and development activity, and apply to projects in which CNOOC is involved. Those might pose complexities. Those might pose practical operational issues for you, depending on the facts. So I don't think that the fact that CNOOC is a 5% partner in the JV necessarily precludes the engagement. But we're starting in your question from a point where you don't have the ability to oppose the assignment. And that I think highlights a different issue, which is whenever you're looking at these territories that might pose sanctions risk, and here I think we are now clearly in a space where China poses heightened sanctions risks in a way that maybe wasn't the case 5 years ago. You really have to think ahead about what your contractual obligations are and how changes in the counterparty's status could impact your ability to deliver, your ability to perform, and what protections you might have. So in your fact pattern, I think the short answer is I don't think the 5% partnership precludes your participation, and that's a function of the particular sanction status of CNOOC. But we would need to look at other factors here, including what are you actually, what's your role? Does the role involve you or some other party exporting products that might be restricted? And then what other contractual rights do you have that you should take into account at this point given the possibility of a change in CNOOC status. So I hope that answers the question. I know it's not a black and white answer, but it's not a black and white area. So, so I think just maybe turning to kind of the early signals from the Biden administration and what we started to see from them before digging into the key programs. One is, if you look at statements from Secretary Yellen, from President Biden, from Secretary Raimondo on the export control side, a key theme is aggressive enforcement of sanctions designations, continuation of the theme from the prior administration, where we saw a proliferation of the use of these tools, both sanctions and export controls, really, and all of the indications from the leadership of the incoming administration, the new administration, is that should continue, and we've in fact seen that in the first few months of the administration. A continued push on China. China factors very, very prominently, as does Russia, but very prominently in the administration's thinking on national security in a whole host of areas, but certainly this is key among them. And again, we've seen both of the secretaries that I've mentioned, as well as senior leadership at the State Department and the president, talk about the use of sanctions tools on China. And more importantly, we've seen continued use of both sanctions and export control tools since the administration has come in. That has not been lost on China, who have responded by setting up new countermeasures, legal frameworks that I mentioned earlier, and that create risk for certainly American companies, but also European and other companies with interests in both markets. Increased enforcement resources, very tangibly, there are increased budgets, requests for increased personnel on the enforcement side, as well as on the targeting side, the side of the OFAC House that involves monitoring things like how Venezuela gets its product out to market, identification of third country companies that may be involved in that activity, and making decisions about who to add to the list. And that's again reflected in the very prolific activity on the designation side. Increased intersection with export controls. So whether it's Russia or companies like CNOOC and others, we're seeing increased use of those tools, and then a new emphasis on forced labor and human rights issues in connection with sanctions. I know we're coming up on the end of the hour, so I want to just quickly touch on some of the key programs and what we are seeing in those programs. And I'll start with the two most important very quickly. Russia. This is one that takes up a lot of our time, both because of its complexity. It is a more nuanced regime than when we think again about North Korea, Iran, et cetera, and because of its importance in the energy and other sectors. Here again, I think the signals are the same. Biden administration came in signaling a robust commitment to using sanctions tools to confront Russia, a desire to be more predictable, essentially telling Russia that actions will elicit reactions that can be predictable, relying on the sanctions, and a more coherent approach to Russia. In practice, we've seen this. We've seen the Biden administration, for example, introduce new sanctions on Russia's access to sovereign debt, restrictions on financial institutions participating in that debt, continued enforcement activity in the energy sector, which is a key sector and component of the Russia sanctions program. I think key things to watch here are that we see Russia issues pop up outside of Russia all over the world, particularly in Latin America, where Russia has significant interests, in Asia, where Russia coordinates closely with China and Japan and others. Russia intersects a lot with Venezuela, and that has created some complexities as well. We've seen many Russian entities designated under the Venezuela regime because of their cooperation with the Maduro government. Russian counterparties, in our experience, are very educated about the sanctions issues. They've been dealing with them since 2014 as targets of those, so they know the ins and outs, certainly the large state actors, but they may create their own problems particularly when it comes to contract issues. We see lots of parties dealing with debt collection, invoice terms, payment terms in energy sector projects that are created in part by how the Russian counterparties address those issues. We've seen a number of enforcement actions involving those kinds of issues. U.S. Customs is actively, we think Customs is an inbound agency. They're actively monitoring outbound shipments, particularly to the Russian energy majors. We've seen detentions and seizures of major equipment that's headed for production and development projects to understand whether those projects are involved in the Russia sanctions. And here again, having a good diligence package can be a lifesaver in terms of being able to convince those authorities to release the goods. But there is certainly increased monitoring and enforcement in that space. China, again, I'd highlight increased uncertainty and complexity, principally because of the way that the US administration has been, and certainly including the Biden administration, has been willing to target major companies like CNOOC, Sinopec, and others. And this is a key area, I would say, of emerging risk and conflict of law issues. Jason, maybe you can go to the next slide and I'll quickly cover the others.
Sorry for doing it early before Tamer. Go ahead.
No. Thank you. So just very quickly, Venezuela, this is an area of significant dedication of resources that Biden administration, I can say from experience, is very well aware of the channels through which the Venezuelan government gets product out to market. We've seen them targeting very prolifically third country companies, shipping companies, others. They know where every refinery is in the Caribbean. They know, they have a clear map of how the Venezuelan government uses third parties. On Iran, no change in the short term. There's possibility of a larger deal, but that is still very much unpredictable. And then finally on Cuba, there was some hope of relief, but the crackdown in sanctions has quelled that hope, at least in the near term. And finally, I'd just comment on some notable enforcement trends. I would refer you to OFAC's Global Maritime Advisory on illicit shipping and evasion practices for the energy sector. There's some good information there, particularly if you have a compliance hat on some of the things that OFAC is focused on and seeing when it comes to evasive practices and shipping that impact the energy sector. I've already touched on the intersection with export controls. This is an increasingly important area to understand, particularly for energy sector companies that have tended to be more focused on sanctions issues because of the use of those tools more in this space. Due diligence on EPC and project partners. The question that we got involves a project. This is, I can't emphasize this enough. Your counterparty may not be a sanctioned party, but you need to understand who else is involved in these big energy sector projects, because there's a good chance one of the energy majors, particularly in two countries I've focused on, Russia and China, may be involved, and you need to sort of factor that into your thinking on those large projects. And then finally, just to bring it back around to the beginning with Stephen's talk on ransomware, we are seeing OFAC, among a number of other agencies, increasingly focused on ransomware and sanctions issues in the ransomware context. If you do have a ransomware issue, our team works very closely with Stephen's team on those issues, because there are a number of sanctioned parties that are sanctioned precisely because they're involved in illicit and ransomware activity. And so with that, I'll pause and see if we have any more questions. I know we're at the end of our time.
None have come through the Q&A, but I have a question for you, Tamer,
Sure.
and that is, you mentioned Nord Stream, and I hearken back to the beginning of your remarks about the sensitivity to foreign policy and national security and how sanctions fit into that. There's been quite an outcry about President Biden not sanctioning, some of the Nord Stream participants. Is that an example of that sensitivity that you're talking about?
I think it's an example of a few things. I mean, one is it's not entirely surprising. I mean, I mentioned the dynamic of Congress trying to force the president's hand. This is an example of that. in every one of those frameworks, there is a release valve for national security waivers, and that's exactly the valve that the president has exercised. And just to be clear, what the president has done is issue a national security waiver with respect to the Nord Stream entity, the kind of key participants, while at the same time, and since that waiver, in fact, we've continued to see designations of other companies that are facilitators of the project. So not the key company, but other companies under other authorities that target Nord Stream as a project. And so you see this complex dynamic. I think that reflects maybe an uncomfortable reality that we need Germany. We need Germany perhaps for some bigger fights with Russia. We need Germany perhaps with some bigger fights with China. And so this is a complex dynamic. But I will say that when we were discussing Nord Stream even years ago, and the sanctions risk, one of the key things that we're always factoring in is what is the risk to the particular company under its particular circumstances, and what are the possibilities for a national security waiver? And so realistically, it's always part of the discussion when we're talking about that kind of framework.
I want to thank the panelists today for their contributions, and all of you for joining us this morning. Thank you very much.